recall a little high school geometry, and I kind of liked it then, of like you find a postulate and you can reason through two theorems. And if your premises are right, and if your reasoning process is right, you can reach specific conclusions that are correct if the initial premises are right. I think that applies to constitutional reasoning too. If you can come up with a sufficiently determinate proposition of law, you may derive other correct propositions from it that may be right, even if they do not correspond to anybody's specific intentions or expectations. Now, it's not a perfect method. It's a method working itself pure, but it is, that I think is basically the core of attempting to understand textual meaning. An important point to this is that for the textualist, for the original public meaning textualist, the implications in terms of outcomes have to be totally irrelevant. They're irrelevant to the task of faithful textual interpretation. We still have to get to what we do with the textual meaning when we have it. You apply these sorts of methodological steps, and I think that any honest interpreter, even an honest textualist, will say that there are some areas where you will have indeterminacy, ambiguity, uncertainty, and even absurdity sometimes. What is the implication of the fact that sometimes when you interpret the text, you produce an indeterminate consequence, or you find that the text is ambiguous? Well, I think that the meaning of indeterminacy and ambiguity is indeterminacy and ambiguity. Sometimes you apply this method and you don't have a determinate answer, but maybe a range of meaning that the constitutional provision would bear. Where the Constitution has a range of meaning, then I think you need to go to sort of second order rules to figure out what you do with indeterminacy and uncertainty as a practical matter once you come to applying the Constitution. Let's turn the page to the question of hermeneutic principles. What do you do with the text once you have it? Now, one thing you could do is you could just ignore it. You could treat the Constitution as just sort of this interesting historical artifact. I think that when you interpret the Constitution, you might apply to it the same principles that you would apply when interpreting the Articles of Confederation. First, you read it to try to understand what it says, and that's an enterprise separate from the question of whether you decide to apply it as law. The decision to be bound and apply the Constitution as law is essentially a political decision extrinsic to the question of textual meaning. I don't regard it as at all impossible that you could say, well, we shouldn't be bound by this written Constitution. Why, in principle, should we be bound by something that was produced by dead white males 200